Got it all done. You got it handled. That's good. And you got me a couple. Right here, there's nobody coming.
They coming?
Yes, ma'am. I sure will. Thank you. Was that what was about?
Doing great. You know Jim McClure? Pete? Hello. Conrad Burns. How do you do? Our new senator. Nice to know you, sir. How are you? Yo vengo de Estado de Nuevo México. Let me get back to you. The hearing will come to order. We are here this morning to begin the process of legislating on the political status. The three options were named, but not described, leaving a vast sea of doubt and ambiguity as to what any of the three meant. In addition, Congress did not indicate whether it would accept a change in status or under what condition which they can choose and expect that an option will be implemented. The process has been designed in close consultation with each of the parties, and I think it is safe to say that the process, at least thus far, and I hope throughout the process, has been endorsed by all. With a constitution that has permitted the orderly and successful development of its resources. It was 53 years ago, in 1946, that I first appeared before a committee similar to this one to oppose a bill by Senator Willard Tidings that would grant independence to Puerto Rico. I had to travel from San Juan to Haiti, Cuba, and Miami by plane, and then by yet achieved independence. The United States is specifically obliged to transfer, and I quote, all powers to the Puerto Rican people so that they can freely determine their own future. Repeatedly, the world community, through numerous specific resolutions, has reminded the United States government of its obligations regarding Puerto Rico. But the United States government has opted, up to now, to disregard the standards of international law in the case of Puerto Rico. It is for us, therefore, cause for optimism that the President of the United States has recommended that this Congress take up the matter of Puerto Rican self-determination, and that Senators Johnston and McClure have included in Senate Bills 711 and 712 an explicit recognition of the applicability of international law to whatever legislation results from these hearings. Commonwealth. Since Bill 710 has been overwhelmingly repudiated in Puerto Rico as being at best a useless popularity contest among undefined alternatives, I will direct my comments to Senate Bills 711 and 712. Although I should make clear that S 712, insofar as it contains a prior congressional commitment to fully defined alternatives, is a better bill. The provisions of these bills fall into the definitions of independence contained in S 711 and S 712 have been proposed by the Puerto Rican Independence Party. In summary, we have formulated an independence proposal which will guarantee the legitimate interest and scheduled for tomorrow, where we will respond to your questions concerning all these issues. I look forward to answering the questions regarding citizenship already put forward. I am, of course, willing to thrust of my comments first to the minimum substantive requirements that must be met by the three alternatives to be submitted to the Puerto Rican people. Bills under consideration be substantially amended. First, it is necessary that the alternatives in the referendum comply with the principles of international law, and furthermore, the process would be inconsistent with the policy expressed explicitly in Bills S-711 and 712, whereby the United States recognized alternative presented concerning Commonwealth would continue to be in flagrant violation of the standards mandated by international law as an alternative. In order to comply with international norms, the present Commonwealth's argument that a status of political subordination, like the existing or like the proposed Commonwealth status, can be legitimate because it may enjoy popular support, is equivalent to arguing that consent is the only requirement for a valid contract.
Cordial saludo a todos. Procedo ahora en inglés. I understood that, by the way. That's right. During the first half of this century, the people of Puerto Rico, then under colonial status, were polarized between those seeking total separation from the United States and those wanting total assimilation to the United States. Violence, turmoil, and bitterness characterized the politics of that period. In 1952, the people of Puerto Rico and the Congress designed the way out of that dilemma, the Commonwealth relationship. This solution gained recognition from the United Nations. Commonwealth arose as the answer to end the colonial dilemma, solving the difficulties in the other options. Independence was and is impracticable for two reasons. It would wreck the Puerto Rican economy, and it runs counter to the unswerving desire of the people of Puerto Rico to maintain their American citizenship and live in permanent union with the United States. It would also disrupt statehood was and is unworkable because it would also disrupt the Puerto Rican economy and does not take into account another given of the Puerto Rican reality, the fact that Puerto Ricans form a people, a distinct society with its own culture, ethnos, and language. This explains the nature of the proposals before you from statehood and independence advocates. Both try to meet the difficulties outlined by injecting generous doses of Commonwealth into their proposals, by delaying the takeoff from Commonwealth for long periods indeed. The process produces some strange results. You are not asked to admit a state in the classic historical and constitutional sense, but rather a body politic aspiring someday to become a state. That unique political entity could not possibly be admitted, as the Constitution requires, on an equal footing with other states, for it would not even be able to keep its own footing. A most singular kind of statehood is being sought of you. It will be, on the one hand, a sort of statehood on crutches, a state requiring special arrangements for an economy which is less than half of that of the poorest state in the Union. On the other hand, this most unequal of states would resist to melt or blend. It would be a state with a different primary language, marching under its own flag, apart from the United States, that one finds from constitutionally sanctioned traditional. Since the 13 colonies formed the Union, the independence proposal is equally flawed. A republic composed mostly of citizens of another state is quite difficult to imagine. This brings us to the real world. The Commonwealth relationship, designed in 1952, has proved to be a workable, down-to-earth way of meeting the aspirations of the Puerto Rican people. The desire for permanent union with the United States, the wish for the fullest autonomy compatible with such desire, the need for preserving their distinct historical heritage and cultural personality, and the necessity for accelerating their economic and social development. Commonwealth provided the necessary flexibility from the U.S. fiscal system in order to implement economic development strategies to rescue the Puerto Rican people from hopeless dependency upon the United States. History has not betrayed our expectations. Through the Commonwealth's association with the United States, Puerto Rico has been able to overcome abject poverty, its small size and remote geographical location, and a lack of natural resources. Under Commonwealth, we have been able to achieve the highest standard of living in Latin America. Puerto Rico's economic development has been possible through the optimal utilization of the tools available only under Commonwealth, such as Section 936. Through the fiscal autonomy that the Congress has granted us, the island was able to attract investment capital and create jobs and opportunities on an island desperate for growth. Today, the livelihood of nearly 300,000 of the island's 900,000 workers depends on the continuity and stability of this favorable business climate. From a per capita income of only 180 in the 40s, Puerto Rico now surpasses 5,000. Production from Puerto Rican factories serves world markets, particularly in pharmaceuticals, medical devices, and electronics. Why then does Commonwealth need to be enhanced? We have come a long way, but we still have a long way to go. Our per capita income is still only 1/3 that of the United States, and our unemployment rate is 3 times as high. As we enter a new century and face the challenges of globalized economies in an ever more interdependent world, broader autonomy is necessary so that we may expand the self-sustaining character of the Puerto Rican economy. There's a need for clear federal policy to support the more assertive role of Puerto Rico in the Caribbean region. there's a desire on the part of a majority of the Puerto Rican people for a broader autonomic framework upon which they can better realize their full potential as a people. In what ways do the bills before you enhance Commonwealth? In four main ways. By enlarging the political autonomy of the people of Puerto Rico, by accelerating their economic and social development, by providing for their increased participation in the United States government decisions affecting them, and by safeguarding their distinct cultural and historical heritage. Of the bills before you, 712 is our choice, because it is meant to provide the voters in Puerto Rico the specific and concrete terms upon which to make the fundamental decisions required of them. In framing the proposal for an enhanced Commonwealth under 712, we propose the precise amendments to the federal laws which clearly define the scope of an enhancement and which make the bill self-executing upon approval by the Congress and the people of Puerto Rico. We would hope that this committee will hold the statehood proposal to this same standard, which it does not meet at present, particularly in the vital economic transition provisions which are totally dependent upon future enactments by Congress of provisions of doubtful constitutionality. The people of Puerto Rico need to know the concrete and definite terms of statehood in order to make an informed decision on matters essential to their well-being. One particular element of our definition of enhanced Commonwealth should be considered at the outset: permanent union. Commonwealth supporters conceive of our relationship to the United States as one of a permanent nature. We do not see Puerto Rico as destined to be a state of the Union, and supporters are second to none in the defense of these rights of all Puerto Ricans. The permanence on which we base our relationship is the only permanence possible in the political relationships of democratic peoples, that their constitutional institutions endure stably into the future, and that when they decide to change them, they will follow the established constitutional and democratic processes to bring about any desired change. Under S-712, the political autonomy of the people of Puerto Rico within permanent union with the United States would be furthered in several ways. Many federal laws are applicable in Puerto Rico today, in spite of the fact that they are not attuned to the particular economic, cultural, demographic, and other conditions of the Commonwealth. Under our proposal, federal laws, rules, and regulations which are inconsistent with the described policy now generally applied to Puerto Rico, by including us in the definition of the word state, would be inapplicable to Puerto Rico unless Congress makes a specific finding that there is an overriding national interest in the applicability of such a law to the Commonwealth of Puerto Rico. Any federal law pertaining to foreign relations, defense, national security, citizenship, and grants and services to individual citizens, however, would continue to apply to the Commonwealth just as they apply in the states. The political autonomy of Puerto Rico would also be bolstered by giving it economic jurisdiction over the waters, seabed, and submerged lands surrounding Puerto Rico, by restoring its authority to issue United States passports, by strengthening its law enforcement capabilities, by enabling the government of the United States or any agency thereof to delegate to the Commonwealth the total or partial responsibility for functions now performed by the federal government, and by promoting the international interest of Puerto Rico to the extent compatible with the foreign relations and security interests of the United States. The economic and social development of the people of Puerto Rico would be accelerated by securing for them more equitable participation in all federal programs that provide grants or services to citizens of the United States as individuals, by authorizing the Commonwealth to consolidate federal grant and aid programs, by endowing the Commonwealth with authority to impose tariff duties on foreign origin products imported into Puerto Rico when consistent with the international obligations of the United States, by enabling the Commonwealth to establish regulation over maritime transportation to assure the lowest possible rates, by promoting the creation of intellectual property in Puerto Rico, and by the United States encouraging other countries to consider Puerto Rico as a developing area for purposes of their general or regional systems of trade preferences. Increased participation by the people of Puerto Rico in United States governmental decisions affecting them would also be assured, and finally, the distinct historical heritage and cultural identity of the people of Puerto Rico would be safeguarded through federal policy. These enhancements of Commonwealth status would provide a broader framework of autonomy under which the people of Puerto Rico could accelerate their economic and social development, affirm their cultural identity, and assume a more proactive role in the Caribbean region. They will go a long way towards updating what was a brilliant solution to the dilemma of a people seeking their place in dignity within the American constitutional system, a people unwilling to give up their identity and culture and the pursuit of their full economic potential through statehood, or to give up their citizenship, economic potential, and permanent union with the United States through independence. These enhancements will go a long way in enabling us as a people and as American citizens to provide a future together with the United States, where we can be true partners, contributing in an increasing way, not only to our progress and well-being, but also to the broader goals of the United States, such as the economic development of the Caribbean basin. Already we are engaged in a task, together with the United States government, whereby we have promoted twin plants between Puerto Rico and 11 Caribbean countries. This effort represents investments mounting to $165 million over the past 3 years, creating 10,327 jobs in these 11 countries. In this, our contribution to regional development and national security, we brought to Grenada 4 manufacturing plants twinned with Puerto Rico. With our Section 936 resources, we're financing housing developments in Jamaica and airlines serving this and other points in the Caribbean region. Young men and women from all over the Caribbean are being trained in Puerto Rico. Not only are Caribbean economies being strengthened in a region where the Cuban model vies for leadership, but more importantly, democracy is being strengthened. A stronger Commonwealth economy, one better able to function under the economic dynamics of a new century, a politically stronger Commonwealth will open the way to greater achievements in Puerto Rico and the region. And it will open the way for the people of Puerto Rico to feel the pride that through their efforts and their devotion to the values shared with the United States, they are helping to build a better future for themselves and their fellow citizens of the United States of America. Thank you very much, Mr. Chairman.
Thank you very much, Governor, for an excellent statement. At this time, were there further statements from your group? At this time, I would like to invite Governor Romero Barceló and Senator Barrios Martinez to come to the table and have questions among the 3 principals for perhaps the next 50 minutes or an hour, and then this afternoon we will get into the further questioning of first you, Governor, and tomorrow our other 2 main witnesses. I think the best case that could be made in the case of tell you that yesterday afternoon the Appropriations Committee cleared my amendment to give $1.5 million, that is $500,000, to each of the parties to cover your expenses, personnel, rent, travel, etc., connected with this plebiscite, with the referenda, should I say. As we speak, it is being considered on the floor of the Senate. The committee amendments were accepted in block with the exception of 2 other amendments, so this amendment has been accepted at least temporarily on the floor, so we are very hopeful that it will be accepted without a debate on the floor of the Senate and later in a conference committee with the House. But I would first like to invite the 3 of you to tell us why it is important, because we may have to argue this either on the floor of the Senate or in a conference committee. I suppose we ought to begin with you, Governor Romero Barceló, since would you begin?
It is important for the appropriation that you're talking about. People, we just went through a campaign in 1988, and we have some debt from that campaign that we have to fulfill. At the same time, and raise the additional funds that are required. At this point in time, we have engaged attorneys in Washington, a constitutional attorney. We have engaged economists to advise us on this intricate problems. We have been using volunteer services up to now, and at this moment, the Governor of Puerto Rico and the Commonwealth is using the people's money to do their job. They travel, they eat, they get lodged in the hotels. They pay all the attorneys and all their help with funds of the people of Puerto Rico. So they're very, very comfortable. But Independence Party and the Statehood Party don't have the funds. We are going to deal with that locally because we feel the use of that money is illegal, but we will deal that locally. Here, we need those funds to have a fair chance. We've had a very great difficulties in getting all of our information available at the times that the Senate required, and we want to meet those schedules, and we want to have this whole process speeded up as much as possible.
Thank you very much. To his credit, although Governor Hernández Colón does indeed have state funds and travel, he is supporting this amendment. Would you like to comment on that?
I'm fully supporting the amendment. I am very much aware of the need of the funds, particularly because of the technical, legal, and economic work that has to be done regarding these bills. I would also like to say that on the 1st of May, the Legislative Assembly of Puerto Rico approved Joint Resolution number 3, which provided $1,350,000 to be equally distributed between the parties so that they may use them for these purposes or other reorganizational purposes in Puerto Rico, reorganization of the parties. So there have been funds, public funds available to all three parties since the 1st of May in Puerto Rico. We fully support the amendment. We understand that it's absolutely necessary to have additional funds.
Thank you very much, Governor. Senator Brios?
I think it's very easy to argue in favor of the amendment. In order for there to exist fair and equitable conditions for all concerned, it is necessary that they have equal access to funds. And obviously that is not the case at the present moment. And the only way to compensate for that deficiency is through this amendment.
Thank you very much. Gentlemen, first with respect to the process, you have all been involved every step of the way in evolving this process and putting in the 3 bills and working with us on the way this bill is handled here in the Congress. Do you have any particular suggestions on how we might improve just the process, the hearings, the method of handling this bill? Is there anything further you'd like to suggest? Any of you?
In the hearings that are going to be held in Puerto Rico very soon this month, I see that I don't know how what the amount of time will be allotted to each one of the witnesses, but I'm sure that there'll be quite a few witnesses that will have some significant contributions to make. That unless they have some amount of time reasonable, and I would call reasonable in at least 15 minutes, that it would be very difficult for them to come up with any kind of a statement, a significant statement in 3 or 4 or 5 minutes. I think that's something that we have quite a few people at home that want to make significant contributions, and it's not the same, just putting it in the record and or having read it out loud or put it forth verbally, because we all know that when these records are going to get big, very, very, very big records.
Well, there's always the trade-off. I mean, we've got only so much time in Puerto Rico, and we can restrict the number of people and allow more time per person, or let more people testify and have a shorter period of time. Senator Brios?
I think that a way should be found for the hearings to be extended in Puerto Rico, geographically and in time. I know that there are difficulties, but I would say that with time enough to keep the timetable as it is, the extension should be made. How can this be done? I imagine there must be ways of sending the staff over, for example, to listen to what people might have to say in different places in Puerto Rico, on the West Coast. At the same time, you keep on conducting your hearings here. I think they should be extended. Besides having more time for those who attend, they should be extended geographically in Puerto Rico. And I think they should be carried to New York also, particularly, and to Chicago, for the Puerto Ricans there to express their feeling regarding this issue, which affects their homeland. So I think both things should be...
Well, again, we've got that problem of the trade-off. As I said in my opening statement, we are committed. Let me speak for myself. I am committed to getting this legislation out of this committee early enough so the process can work. And the goal is referenda for self-determination for Puerto Rico. It may not represent everything that everyone wants, but if we're going to do that, we've got to we've got to push and we've got to move, and we cannot have too many hearings. And there's so many serious questions here, constitutional questions, legal questions, that involve lawyers and specialists and technicians. We've got to allow time for that kind of thing, because that is of first importance. The allowing ordinary citizens to testify is important in the process too, because they must feel that they are a part of this. But we don't want to make them such a part of it that we don't have time to legislate, because we've got to keep our eye on the ball and the fact that we've got to have that goal. So as time goes on, if the three of you can keep the excellent relationship you've had, tough competitors, but able to talk between yourselves on advising us, we would very much appreciate it.
Well, Mr. Chairman, can I make one suggestion? Something that we discussed earlier, which is we would like to see the local Department of Justice, U.S. Department of Justice, and the federal courts have jurisdiction, particularly pertaining any tampering with the process. We're having problems right now with the elections in San Juan, and they're being questioned. And we certainly would not like to go to the elections with the same persons that are going to be controlling the elections, unless we had some forum that we could feel there would be more objectivity, where we could...
It has been held to be a fundamental right, and under Buckley versus Vallejo, that is a First Amendment right that they are protecting. Now, let me ask you a troublesome question to me, that the legislation as we initially introduced it and as further expanded provides, in the case of S-712, for self-executing status, but it provides that status may be achieved with only 50.1% of the vote, 50, and that they could not consider another choice then, but that you would then have a further election with a requirement to have something above 50% in order fully to effectuate that status. Is that fair? Keeping in mind, for example, that Hawaii and Alaska both had referenda before they were admitted into the Union, and had that approved by 90%
vote for it. But I disagree with him when he says we don't have a right to be a state. I think we do have a right to be a state, because all being a state means, as far as we're concerned, is the right to vote and the right to representation, the equality. That's a basic issue, and all American citizens have a right to equality, have a right to vote, and have a right to...
And a change to a totally different status. Commonwealth was established in 1952. We are not seeking to change the nature of that status. We are seeking to enhance it in the different ways that we have discussed here. As Senator McClure himself said, these enhancements could come by the way of congressional legislation, but then their nature would be different, because they would not be proposals to the people of Puerto Rico to be accepted in a referendum, and therefore they would have a force and effect by the fact that they were legislated by the Congress, but not by the fact that they had the acceptance of the people of Puerto Rico, and therefore they were joined in compact. So there's a basic difference here. Now, historically, the vote for statehood, as you very well know, has been a vote of very, very large majorities. It does entail a very fundamental and radical change. Independence also entails a very fundamental and radical change. So it's not a question of abstract rights that's been raised here. It's a very fundamental political decision to be made between the people of Puerto Rico and the Congress of the United States. And therefore there should be the necessary solidity to whatever decision of that nature is made.
Governor Hernandez Colón, you have made statements to the effect that Section 936 would not be possible to be extended under statehood. I wonder if you would make that statement and give Governor Romero a chance to respond to that, because that's one of the key arguments you've made.
I have two things to say about that. First of all, that they do not address the problem in their proposal. S-712, it's supposed to be a self-executing bill. And although Section 936 is mentioned in S-712, it is not mentioned in the way that it would need to be mentioned, so that a precise amendment to the Internal Revenue Code is made in order to make it operative under a statehood situation. It just says Congress will do this at a later date. So that's the first problem, that it is not precisely and concretely addressed in the technical legal language necessary to do so. Now, with regards to that particular legal language, and assuming that we would have it before us, that credit structured for a state would come into conflict with the uniformity clause of the Constitution that requires that taxation should be uniform throughout the 50 states. So we have here a credit within the Internal Revenue Code that is applicable only to Puerto Rico. That is the constitutional question that would then be raised if they had proposed the technical amendments, which they have not.
Governor?
Yes, Senator, Hernandez Colón is an attorney, and so am I. Neither of us are constitutional experts. The Commonwealth proponents have used the services and used the opinions of Professor Lawrence Fry from Harvard. We have happened to now we're using the opinions and recommendations and advice of Professor Paul Gewitz from Yale University. So Professor Gewitz will be available tomorrow at the 2.5-hour session to explain precisely from a constitutional attorney's point of view why it is constitutional to extend 936 for at least for a period of time within statehood. I want to point out further, Senator, these two books I have are 2 volumes, which are the most comprehensive study that has ever been made about the admission of the original 13 colonies as they became a nation, and the 37 states that were then admitted into the Union, the whole process that went through in every single instance. This book was prepared by the Grupo de Investigadores Puertorriqueños, a Puerto Rican investigation group, and it is a very, very comprehensive and complete study. In this book you will find, and they were distributed to the staff members of the senators, and if any don't have it, please let us know. We would be very glad to make it available. In each one of those, they study case by case, state by state, all of the special agreements and all the special accommodations that were made for every territory. And the most recent ones were, of course, Alaska and Hawaii. Alaska, for instance, as far as the excise tax on oil is concerned, they're exempt 90%, and that's by law. And that was challenged, and the Supreme Court said no. But those things are things that can be explained much better by Professor Gewitz. And I just wanted to add, in here you will see also in the study that not even a majority has been required for statehood throughout the history. There were cases where before the Admissions Act was put forth to the people, the vote on the plebiscite, on the referendums, had been even less than a majority for statehood. In the case of Wisconsin, it was 22%. In the case of Nebraska, it was 47%. In the case of Colorado, it was 45%. So they didn't require a majority before the Emissions Act was presented to them. So I think tomorrow we will be in a much better position with our legal advisors to address that question. And Mr. Gewirtz has prepared a written statement, very, very, very thorough, I think, and excellent, that addresses itself to all those issues that have been raised.
I think that would be helpful to have him here. Understand the Finance Committee has jurisdiction of Section 936. I would expect that we would at least make recommendations to the Finance Committee and at least deal with that question in in some manner, in a preliminary manner at least, because that's so intrinsic to the whole statehood situation. And I am encouraging the Finance Committee to begin hearings early on because it is so tremendously complicated, so technical, and they will need time within which to deal with that. Senator?
Yes, regarding this matter, I must point out the following. In this area, like in other areas which will be considered by this committee, there's nothing statehood and Commonwealth can do that independence cannot do better. There's no way in which you can make 936 permanent or semi-permanent, either under Commonwealth or under statehood. It would be there for a number of years, X number of years, subject to the will of the Congress. If you wanted 936 for 15, 20, or 30 years, and the Puerto Rican people wanted 936 for so many years, then we could enter into a treaty, and then 936 could be finally permanent. So there's a lot of flexibility from no permanence at all to halfway permanency to 50-year permanency in independence. And I must remind you this. I must also point out, for the record, that it is true that some states have been admitted without the majority of voters. But these are not peoples. These are American people who live in Wisconsin or Colorado. In Puerto Rico, we're talking about the Puerto Rican people, and that's a basic difference.
On that subject,
Mr. Chairman, might I just interject one?
Concern now is to get the Finance Committee involved, not to steal their jurisdiction.
I agree.
Senator, I would like to say that our bill does not include any amendments of the Internal Revenue Code.
Yes, we understand that. Senator Barrios, you said you're dealing with the people of Puerto Rico, implying that there's a difference between the people and American citizens. If the Puerto Rican people opted for independence, would it not be appropriate then to have them make a choice as to citizenship, American citizenship or Puerto Rican
I would
citizenship?
have no objection to that, but the fact is that the United States Supreme Court has an objection to that.
Having been born an American citizen, it cannot be, it is indefeasible,
Right.
Whereas if it is from...
But we're talking of citizens by birth in 99.9% of the cases, because almost nobody who was born before 1917 is now a Puerto Rican citizen. But this is a question we can talk about. I have no objection of comparing constitutional notes. We have made our proposal because we believe it's in accord with U.S. Supreme Court decisions.
Right. Puerto Ricans do have 14th Amendment citizenship. That is, those who were born in the United States or within persons involved would be small. That is, so apparently there is, well, I will share this opinion with you. Are not applicable after those laws, rules, and regulations are passed, in which event then the executive or the Congress would have to make a determination as to whether they applied?
Request in that direction is not exactly that. We request that a federal policy be established that will alter the criteria presently existing for the applicability of federal law, because it is very vague. It's the criteria of locally inapplicable, and because the practice that the Congress has followed is to include Puerto Rico in specific legislation by treating it as a state. We propose a more discriminating treatment for the extension of legislation to Puerto Rico. This treatment would not apply to laws in the matter of foreign relations, defense, national security, citizenship, or federal programs extending rights to individuals. It also not apply in any given circumstance where the Congress finds that there's an overriding national interest that a law of any nature, not of the categories I mentioned before, should apply to Puerto Rico. Now, given those exemptions, then the criteria would be whether the particular law is consistent with the federal policy to be adopted as a result of the referendum. And this policy would be as follows. The policy of the United States shall be to enhance the Commonwealth relationship enjoyed by the Commonwealth of Puerto Rico and the United States to enable the people of Puerto Rico, one, to accelerate their economic and social development and attain maximum cultural and political autonomy within permanent union.
Let me interrupt you at that point, because it seems to me that your proposal would be productive of endless litigation to determine whether it was consistent or whether it had a proper regard for federal law. For example, Coastal Barrier Resources Act, would that have a proper regard for ecology, or would it be considered a proper regard for economy?
I'd say no.
I wonder if, for example, we might put in a proposal that said in these categories, specific categories, that the law would be, a rule of statutory interpretation would be that it did not apply unless Congress said it did apply. A rule of statutory interpretation, which of course could be overcome either by stating specifically in the law that it does apply, or by statutory history.
I would not like to answer to that. I think we have a problem that is recognized by our proposal in the bill and by your suggestion. I would like to give some thought to that and see what problems may arise.
You will be up this afternoon, and
yes,
we might deal further with that question. It seems to me that you pose a legitimate question that we ought to try to deal with in this legislation, but it seems to me the formula would be a little difficult and productive of litigation.
There are many mechanisms that can be thought of, and they have their problems, and we're certainly willing to look at alternatives.
Obviously, I've got a lot more questions, but let me turn questions over to Senator McClure at this point.
Well, Mr. Chairman, in view of the time, the options as you gentlemen see them, so far as the Congress is willing to accept the proposals that are made, because I understand that we may have the power to do that, but on behalf of the people of the state of Idaho, I sometimes resist the exercise of that power.
Resist it all the time. That's why I believe in independence.
The second question, with respect to the ballot language, obviously you cannot include on the ballot all of the proposal. There has to be some description of the alternative so that the people of Puerto Rico can indeed read the ballot. I suspect there will be some few who go to the ballot box without having read the entire proposal of any one of the parties, let alone all of the parties. I don't know if that will just lead them to check the fourth box that says none of the above, or what result that might have. But I am concerned, as I think we all must be, that the people of Puerto Rico be given an honest choice, and that it is a choice which we in the Congress of the United States are ready and committed to observe. I think that's fundamental to this proposition. So that we need to understand from our end, at the Congress of the United States, what is being submitted as options that we're ready to support when chosen. And secondly, so that the people of Puerto Rico can know what the options are and they make an...
The proposition that would be actually submitted to the people of Puerto Rico would not be Commonwealth itself, but rather the enhancement of Commonwealth. So we need to define in somewhat broad terms what this enhancement would be. We have suggested the language here in our proposal, and it reads, enhance to enable the people of Puerto Rico to accelerate their economic and social development and attain maximum cultural and political autonomy within permanent union with the United States based on the irreversible bond of American citizenship, a common defense, a common market, and a common currency. And that would be the definition that we propose to the Congress that be submitted to the people of Puerto Rico.
While conveying some information. I'm sure the three of you can agree on...
Senator, I must mention that given the fact that there was a plebiscite in Puerto Rico in 1967, and that there were definitions at that time, there was a definition in particular of the Commonwealth formula, and the elements in that definition, such as permanent union, common citizenship, were essential elements of the Commonwealth proposal, that any change which would affect those essential elements would have a confusing and negative impact upon what the people of Puerto Rico were called upon to vote, because Commonwealth has been defined in a certain way. And so defining it in a different way would carry with it the connotation that Congress does not accept that particular definition. And that would be the problem. Now, I don't, suggest that we call it the Great Commonwealth or anything like that, but that those historical elements that have been before the people of Puerto Rico should be a part of the definition.
Senator?
I think we should make this point clear. I think the question is very important, and I think we can agree, but a reference has to be made to the self-executing treaty as a whole. Congress in 712 at least is going to make an offer. We want pressure so that whole offer would be in the ballot box, but the people will have to know that it is about and referring to that offer that they're voting, and that offer is extended. How do you get the people to know the offer? That's a procedural matter which we can deal with. But I think that has to be...
Senator, I agree with the point that you make. And Governor Romero?
Yes, I want to make another point. We cannot take the plebiscite of 1967 as a precedent, because there are certain things that happen in that plebiscite that are not present now, which we objected to from the beginning. We went to the plebiscite because we had no choice, because there was going to be an offer of a vote, and if we didn't go, we boycotted, as the Republican Party did then we would be out in left field, and it would be only a one-way contest, and they would then say, well, here, the vast majority of the people of Puerto Rico, it's almost overwhelming for a Commonwealth. So we had to go, but the Popular Party was in control of both legislatures, overwhelming majority in both legislatures, and they passed a bill where the statehood was not defined, independence was not defined, they only had an embellished definition of Commonwealth, then we had to go to that plebiscite. It was not accepted by the statehood party. It was not accepted by the independence party. The statehood
States was shaping its policy regarding the status of Puerto Rico. The colonial relationship and precisely the change recognized by the United Nations in 1953, declaring that the colonial relationship had ended. The Commonwealth relationship represents, in sum, analogies must be cast aside. The yardstick is not whether a given power is or is not enjoyed by a state. The test is whether the proposed reform is in line with the reason and purpose of the unparalleled Commonwealth. Principles inherent in our relationship can and should now be developed to their full potential. The referendum proposition for the enhancement of Commonwealth will appear in the ballot in Spanish as follows. El Estado Libre Asociado se fortalecerá para acelerar el desarrollo económico y social y alcanzar la máxima autonomía cultural y política del pueblo de Puerto Rico en su unión permanente con los Estados Unidos sobre los pilares de común defensa, común mercado, común moneda y el vínculo indisoluble de la ciudadanía americana. And in the blanks, saying one thing in Washington and another in San Juan should be avoided. The people of Puerto Rico are entitled to an informed choice. Voting in the dark as far as government decisions affecting Puerto Rico, safeguarding the cultural identity of the people of Puerto Rico, and protecting the bilateral, non-colonial nature of our relationship. This policy would govern the next phase of the Commonwealth relationship. The elements of this policy have been present since its creation. Therefore, a broader local autonomy, the 1900 General Assembly of Puerto Rico, to have a meaningful say in the applicability of federal laws. Other societies have met this problem. The British solution was the Statute of Westminster. One has requested an analogous solution. Our proposed solution is different. Consent is granted to the applicability of federal laws relating to foreign relations, defense, national security, citizenship, and to entitlement programs which are rights inherent to U.S. citizenship. Other federal laws are applicable only if consistent with the law, unless Congress finds that an overriding national interest requires their application in Puerto Rico. As under current law, local inapplicability is subject to judicial determination. Our proposal also includes a mechanism for case-by-case participation by the Commonwealth in determination of local geography or separate in its future and fate from the rest of the Caribbean and the world. We are playing a vital role because international law has been recognized by the United States. To further our contribution to national security and regional development, Puerto Rico requires a clearer federal policy in support in decision-making in Puerto Rico's international action, and will further our common interest in widening opportunity in the Caribbean. International commerce and trade, the gateway between Latin America and North America and Europe. Our aviation proposal would designate Puerto Rico as an open port for foreign air carriers. 10% of those come from the United States. This ocean we recognize the overriding national interest. We do propose, however,
of U.S. citizens in Puerto Rico for more equitable participation in federal programs, providing them with grants or services. We propose to achieve parity with the United States over the next 4 years in the Nutritional Assistance Program, the equivalent of food stamps, AFDC, and Medicaid, and over 8 years in the Supplementary Security Income Program. We believe that the U.S. citizens in Puerto Rico, like their counterparts in the States, are entitled to a minimal safety net without requiring them to leave Puerto Rico to gain full assistance. An existing inequity under present law is that more than 121,000 aged or disabled Puerto Rican residents not now eligible for assistance under SSI receive a total monthly assistance of $32 compared with $314 in the States. Inequities of this nature among fellow citizens are contrary to the essence and dignity of our common citizenship. As stated earlier, another primary objective of the federal policy to be established is to accord the people of Puerto Rico greater participation in federal decisions affecting them. There are several ways to achieve this objective under Commonwealth. We propose to increase participation through a role in federal appointments on the island and a non-voting delegate to the Senate. Currently, federal appointments serving in Puerto Rico are made with little, if any, consultation with the government of Puerto Rico. In order to make the exercise of executive power more consistent with the principle of government by consent, we propose that the appointment of any high-ranking federal officer serving in the Commonwealth, as well as any other appointments subject to Senate confirmation, be made from a list of eligible candidates recommended by the governor, who is the highest elected official in the Commonwealth. Puerto Rico has been represented in the House of Representatives by a resident commissioner since 1900. His representation of the interests of the more than 3 million United States citizens of Puerto Rico contributes to the decision-making process of the House with respect to Puerto Rico. We seek similar representation in the Senate. The multiplicity of legislative problems affecting Puerto Rico and the Senate's exclusive role in treaty-making and presidential appointments make this representation vital to us. Our non-voting representative in the Senate would have all the rights and privileges of other members as are compatible with the Constitution of the United States. The exercise of federal judiciary authority must also be made more coherent with the nature of the Commonwealth relationship. As the Supreme Court has recently stated, a rigid rule of deference to interpretations of Puerto Rico law by Puerto Rico courts is particularly appropriate, given the unique cultural and legal history of Puerto Rico. In line with this ruling, we set forth an abstention rule to govern the federal court's interpretation of unconstrued Puerto Rican statutes and regulations. To assure uniformity in the interpretation of the essential elements of the relationship and in the interaction of the federal judiciary with the Commonwealth government, we propose to centralize consideration of these matters in a single court. To further the accessibility of federal courts to citizens seeking to vindicate their rights, almost 60% of whom speak no English, we propose that the proceedings be conducted in Spanish. The Commonwealth has attracted many illegal aliens from nearby island nations. The admittedly limited resources of the central to the policy to be established through the referendum is the protection of the distinct identity of the people of Puerto Rico. Under our proposal, public lands and properties significant to our people and history would be returned to the Commonwealth. Title to real property acquired by the United States from Spain under the Treaty of Paris, so-called Crown lands, and to the lands administered under the Caribbean National Forest, El Yunque, would be conveyed to Puerto Rico. The United States and the Commonwealth would negotiate conditions for the administration of such lands and properties. No military bases would be affected by this proposal. Finally, we include a number of other important proposals: the exclusion of Puerto Rico from the Coastal Barriers Resource System, the delegation of the administration of federal labor laws, the authority to issue passports and special entry visas, and the necessary authorization for the adoption of voluntary programming codes by broadcasters. Such is our proposal, detailed and specific, to provide for a more effective governance for the people of Puerto Rico, to assure economic progress, political stability, and cultural identity. A Commonwealth statute could occupy that territory.
But it would be up to the Congress or the agency or the administration to interpret the phrase consistent with federal policy or consistent with Puerto Rico. Is that correct? I mean, that's not something for the court to determine. That's something for the agency or the administration of the Congress to determine.
There's a mechanism providing for the Puerto Rican government and the Congress to make that determination, where the Puerto Rican government would make the proposal to the Congress. There is also a provision for judicial review of inconsistencies with regards to laws falling in that category. So there are two mechanisms running parallel.
Well, because the intent and to state it, and it seems to me we ought to at least to have a rule of statutory construction, to have a what may amount to a partial veto of law or regulations after the fact seems to me to be not good policy and not to be workable, but I don't know what the reaction of the committee will be to having a resident commissioner in the Senate. There are a lot of arguments pro and con that, but to the extent that we had that, would that solve a lot of these problems where you could, during the debate of a bill, you could ask the question, does it apply?
That would certainly help a great deal. It's still a problem existing at this moment, even with House legislation, but certainly the presence of the commissioner could help a great deal. Perhaps address
Yes,
this
Mr.
question and give us the benefit of his experience.
Yes, Mr. Chairman and members of the committee, the first part of our proposal, the one that deals with the federal policy, would set some standards to guide congressional and executive action in deciding which legislation and regulation should be applicable to the Commonwealth of Puerto Rico. You raised a question this morning, Senator Johnston, on whether this was the best way to do it or not. And I think that you should know that in most of the cases, the problems that we envision are actually solved through the internal dealings that the resident commissioner has with the different congressional committees whenever legislation comes up. I have a list here, for example, in the last 4 years of at least 6 cases in which important and even major pieces of national legislation, at the beginning, we're dealing with Puerto Rico the same way as it dealt with the states as a whole. And after we intervened to show why it would create a very difficult or distressing situation in the island, the adjustments were made by the corresponding committee. And
No. Ah, bueno, en el overriding sí, en el overriding. Estaba preguntando sobre los, depende de lo que me esté.
You or your counsel looked at the mechanism of that as to how it could be mechanically phased out without reference to the number of years. Let's say you wanted to pick a number of years on Section 936 and phase it out. Is there a mechanism by which that can be done? In the statehood, it says you shall start negotiating after 10 years. If nothing happens until 15 years, then you take it down 10% a year for over a period of 10 years. So that in effect it would last 15 years unabated and then go down 10% a year for 10 years. My question is, as a mechanical, workable thing, not with reference to the merits of whether it's a good or bad idea, can that be done, or must it be amended in another way? And I'm not talking about the uniformity clause now, I'm talking about just the mechanics.
Have to ask my counsel.
If Mr. Kopakin wishes to testify, we'd...
Did propose, when we were dealing with the problem of 936, another mechanism which they found consistent with statehood, and it was the mechanism of the wage credit. This was proposed by Baltasar Corrada to the Secretary of the Treasury, I think in Huh? 85, and there's a letter from him, so you might want to look at that.
Much, Governor, and Commissioner
Thank you.
Fuster, and
Thank you.
President of the Senate, and Speaker of the House, for your attendance. You have been very helpful. Your statements have been very good. In fact, all of our testimony has been excellent today. Tomorrow morning, we will begin at 9:30 with Senator Rubén Berrios Martinez, and at 1:30 p.m., Governor Carlos Romero Barceló, and that will terminate our hearings, the afternoon session tomorrow.